We always want to make sure that everyone is on the same page. That's why it is worth taking a little bit of a closer look into the Wolford and May opinion on sensitive places. Let's talk about it. Hey everybody, welcome back to the channel today. That is right, I thought it would be a good idea to take a little bit of a closer look as far as this opinion is concerned for Wolford and May, that is on sensitive places. To walk us through that, a friend of the channel and an attorney over at Michelle & Associates, we have brought back Kostas Moros. Kostas, thank you for being with us today.
Always a pleasure, Kevin. Thanks for having me on.
Absolutely. Guys, before we get into that today, though, please be sure to like, share, and subscribe to these videos. It really helps with the algorithms to push this message out as far as it can possibly go. We're looking to have the Second Amendment on people's minds as they go to the ballot box at the end of this year for the general election. So please, any likes, shares, and subscribes will certainly help get that out there. So, Kostas, let's just jump right into this here. I do want to individually go through what was won and what was lost with this opinion. But before we get to that, there was a little bit of a foundation that the judge really seemed to want to make clear in this opinion, and it seemed to want to lay the foundation for why these laws should be upheld, even though they weren't able to uphold all of them. Jacob, if you could put this part of the opinion on the screen, it reads like this. We conclude that the proper approach for determining whether a place is sensitive is as follows. For places that have existed since the founding, it suffices for defendant to identify historical regulations similar in number and time frame to the regulations that the Supreme Court cited as justification for designating other places as sensitive. For places that are newer, defendants must point to regulations that are analogous to the regulations cited by the court, taking into account that it is illogical to expect the government to regulate a place before it existed in its modern form. For example, it makes little sense to ask whether the founders regulated firearms at nuclear power plants. So, Kostas, I guess my question to you is this. I mean, we've had this conversation on a different topic, but for a long time. And let's just go to the First Amendment argument that a lot of people have had. The Founding Fathers, I'm sure, never imagined the internet or something like social media, yet we continue to see freedom of speech rights upheld for citizens using the internet. Why does that seem like it's not really translating and applying here to firearms? Is this something that we should accept as precedent from an opinion?
Oh, no, it isn't something we should accept, but it is something that should be expected from a panel like this one, which was not favorable to us. And they realized that if they hold this to the actual founding era analogs, which was guns could be prohibited in, legislative assemblies, polling places, and courthouses, and that's pretty much it, then they would not be able to have this expansive, sensitive places case. In fact, if I'm being honest, frankly, I'm a little bit pleased that they even gave the concession that if a place has existed since the founding, there is at least some bit more strictness involved than somewhere newer, because I didn't think we'd even get that much from this panel. And in a lot of ways, when you consider the makeup of this panel, the fact that we won as much as we did in this case is kind of surprising, better than expected, because I was frankly expecting a bad loss here, and we got kind of a split decision. So the analysis isn't correct, and we're hoping it'll be corrected going forward, but it isn't surprising to me that they landed this way.
Well, speaking of that panel, I did want to go through these, and I'm going to consult my list here so I don't leave any of them out individually with you, just so that we are all on the same page. You got essentially two major lawsuits here, one out of Hawaii, one out of California, a lot of challenges, some of them similar, some of them not, but as far as the injunction being upheld, in other words, a victory for the firearms community, you had these things. You had shared parking areas with government buildings. You had the vampire rule in California, although we'll get to that one in a second. You had places of worship, public gatherings that require a permit, financial institution, and medical facilities. So these places, the injunction was upheld, which means firearms for CCW holders are still permitted. As far as the losses are concerned, or where the injunction was removed, you have parks and similar areas. You've got playgrounds and youth centers, bars and restaurants that serve liquor, places of amusement, parking areas connected to sensitive places, and public transit. You already kind of mentioned the makeup of this panel, and let's go ahead and leave aside the vampire rule here for a minute. Are any of these a surprise to you, wins or losses? I know that the panel was not favorable, but is there anything pertinent for CCW holders to know given this list of wins and losses?
Well, one correction, first of all, we actually won on public transit, and that's important because that's probably the biggest surprise of the case. After the vampire rule, I thought the public transit restriction in SB2 was the most malicious because the legislator knew by doing that, they were taking away the right to carry from anyone who relies on public transit. And this panel, to their credit, acknowledged that. They said it would not be just to basically deny these people the entire right to carry because they don't have a car to get around. That was a surprise to me, a pleasant surprise, and probably the biggest win we got from this panel was on public transit. But otherwise, your list was correct. I am disappointed. I can't say I'm surprised with too many of the losses because, like I said, I thought we'd have more losses. So if anything, I'm surprised by the wins we got. But I'm very disappointed in parks and places that serve alcohol, especially. And that's because places that serve alcohol, none of our plaintiffs really go to bars or nightclubs. That's not really what they're concerned about. I'm not saying such restrictions are constitutional, but that wasn't their concern. Their concern was that now you can't go to a Chili's or an Olive Garden, even if you have no intention of ordering beer or wine, just because they offer beer or wine on the menu, and that's not just. And then on parks, of course, they didn't even differentiate between state parks. Not only can you not visit an urban park, if you're out camping, you can't carry a gun in the wilderness for your own self-defense. It's preposterous. And the panel even alluded to in their analysis that rural parks and state parks are probably not sensitive, but they claimed falsely, actually, that we hadn't leveled an as-applied challenge as to those, but they forgot that it's actually a different code section in California law, so we didn't need to. We could do a facial challenge as to rural parks and succeed. So yeah, those are the most disappointing losses. But I'm actually, I don't want to say pleased because we're about to get to the vampire rule analysis, but I'm pleasantly surprised with how much we won in this ruling.
Well, certainly a lot to keep up on as the case continues to progress. But yeah, let's hone in on the vampire rule really quick. This was one, they grouped in the opinion, they grouped up some of these things to tell us whether they thought the plaintiffs were likely or unlikely to succeed on the merits, which is how they come to the conclusion for the injunction. But for the vampire rule, there was a challenge in Hawaii, the Wolford case, as well as the May case here in California. They actually differentiated these two within the opinion, removing the injunction for the Hawaii side, but keeping it on the California side. Can you let us know really quick, what is the vampire rule and what's your analysis on why it was kept in California? And is that going to be a focal point moving forward?
Sure. So the vampire rule, we've nicknamed it that because it's actually known as a private property default rule in that you can't enter on private property unless you have permission from the owner. So up until now, it's always been if they don't want you on their property because you have a gun, they put a no guns allowed sign or some other indication. So now this rule flips that on its head and said you actually have to be invited in. So one of my buddies on Twitter came up with the term vampire rule because in the old folklore, for a vampire to enter your home, they'd have to be invited in. Otherwise, they wouldn't be able to enter the residence. So that's where we came up with that. And also, we don't like to call it a default rule because it's not actually a change in the default for anyone else. If you're a retired policeman, a cop, a whole bunch of other exemptions, this doesn't apply to you. The law only applies to people with CCW permits. So the default hasn't really changed. But anyway, the panel differentiated between Hawaii and California's laws because Hawaii's law is a bit more permissive in that it allows any form of consent, not just a sign. So you can post a sign, but you could also give people, a business owner could give people their verbal consent, email, text message, whatever else, if they ask them. And as long as you have some form of consent from the operator of the business, you could enter. Whereas California's law specifically says a sign is required to allow entry. And the panel zeroed in on that and said that that distinction makes California's law unconstitutional because it's not in compliance with history, whereas Hawaii's law is in compliance with history. But of course, the history they cited was just one law from 1771, which was about hunting, and one law from 1865, which was a black code passed after the Civil War ended to basically harass freed black people. So I don't think the panel even realized the one they cited from 1865 was a black code, but that is frankly should be a little embarrassing to them. And we'll see how that plays out going forward.
So what does this look like going forward? We've gone through all the points here. The injunction was kept for some of these things. It was removed for others. Where does this case go from here? Does one side or the other appeal this opinion even higher? Does it continue to be litigated in the federal district court? Where do we go from here?
So normally you would go after preliminary injunction ends. You could either appeal up to the Supreme Court or en banc to the Ninth Circuit, or you could go back down to the district court and get a final judgment and then come back up. We don't know what the state will do. I imagine they're not going to appeal because this was such a favorable panel to them that it probably can only get worse for them if they were to appeal. But we are leaning towards filing an en banc petition for review. I can't confirm for 100% for sure, but we will know in the next couple days. It's looking like we're going to do that because my understanding is plaintiffs in the other cases will as well. We don't know if the Ninth Circuit will take it en banc, and I don't think at this time we intend to pursue it in the Supreme Court. So if en banc review is denied, we'll go get our final judgment. But that isn't 100% confirmed yet, but it is possible that by Friday you will see us file an en banc petition in this matter.
Just really curious, the last en banc hearing or oral argument that we saw, I think it was for Duncan, was it not? And the panel itself of judges seemed to be going through a little bit of an identity crisis, I guess, to put it simply. Would you expect to see that continue for an en banc panel, or do you think that they've sort of figured it out?
Well, remember that en banc panel in Duncan was the same one from 2020 because they took it as a comeback case. If they were to grant, first of all, we're getting ahead of ourselves because we don't know if they'd even grant en banc. But if, let's say they did grant en banc review, then out of the 29 active judges, you would have the chief judge always gets to be en banc, so that's one. And then they draw 10 more at random from the 29. So we could get a terrible en banc panel. We could get a good one. It's up to the luck of the draw. So it wouldn't be the same one as in Duncan. Some of the same judges might be in it, but we could have a totally different en banc panel if this were to be accepted. But I don't want to get ahead of ourselves. We haven't filed the petition yet. We're not 100% positive we're going to file one. But if we do, you'll see it by Friday because that is the deadline. And if we do, then the panel will vote as a whole whether to take the case en banc. Odds are against us. It's a little bit of a long shot, but it might be worth trying in this circumstance.
Well, certainly a lot to look forward to, whether it is getting a petition to the en banc panel or seeking the final judgment as it stands. Still some work to do. We're going to follow along with it. Kostas, as always, I really appreciate you taking the time. I know that you're a busy guy, so thank you very much for being with us today.
Thanks, Kevin. Always a pleasure.
Absolutely. And guys, if you like content like this, you want to continue to be updated on what's going on in the court, if you want to directly contribute to lawsuits like this and the legislative efforts of CRPA, please be sure to like, share, and subscribe to these videos. It really helps with the algorithms, and that all transforms into the movement. Thanks again, guys, and we'll see you on the next one.